What happens when a U.S. senator known for his Southern charm walks into a courtroom and gets publicly mocked by a federal judge? Most expected John Kennedy to laugh it off. Instead, he did something that left the entire courtroom and the country stunned. In the next few minutes, you'll witness a takedown so calculated, so explosive, it's now being taught in law schools. This wasn't just a hearing, it was a reckoning. The courtroom was already tense when Senator John Kennedy took the witness stand. The ceiling fans spun slow circles above rows of sweating lawyers and blinking reporters, but the real heat came from the quiet power play unfolding between two men who had spent their lives on opposite sides of American justice. Kennedy, the silver-haired senator from Louisiana, known for his homespun wit and sharp legal mind, adjusted his tie and leaned slightly forward. He didn't raise his voice. He never needed to. His words, thick with Southern cadence, filled the room with deliberate gravity. "I believe, Your Honor," Kennedy began, "that when government tells people what they can and cannot say, that ain't law, that's tyranny in a tuxedo." The court murmured. A few reporters grinned. Even the stenographer paused for a half-beat before continuing her furious typing. It was a Kennedy classic, sharp, homespun, and packed with constitutional meaning. He was here under subpoena, testifying in a federal lawsuit challenging Louisiana's controversial new law regulating online speech. Critics called it digital censorship. The state called it public safety. Kennedy called it dangerous, but before he could finish his sentence, Judge Andrew H. Stones interrupted him. "This ain't the bayou, Senator," Stones said, his voice dry as desert wind. "We use law, not poetry here." The words dropped like a guillotine blade. The courtroom froze. The tension, already humming beneath the surface, spiked. One or two gasps escaped the gallery. A clerk dropped her pen. For a full 3 seconds, no one moved. Kennedy didn't flinch. His gaze didn't change. He didn't offer a smirk, didn't bristle with offense, didn't respond with one of his trademark jabs. He simply blinked once slowly, as if filing the insult away in a drawer marked "not yet." The stillness in his face was what made it unforgettable. Not outrage, not bravado, just the eerie, perfect calm of a man who had seen this before and who had come prepared. Judge Stones, high on his bench, leaned back with satisfaction, as if he had just asserted the natural order of things. This was his courtroom, and in his courtroom, authority didn't yield to Southern charm or Senate seniority. Certainly not to anyone quoting Jefferson with a drawl. It was, by any measure, a tactical miscalculation, because John Neely Kennedy wasn't just any witness, and this wasn't just any case. The lawsuit at the heart of this clash had been filed by a coalition of journalists, tech watchdogs, and civil liberties groups, all claiming that the Louisiana law effectively criminalized dissent under the guise of moderating misinformation. The implications were enormous. If upheld, it would set a precedent that allowed states to penalize online speech under vague terms of public order. And Senator Kennedy had not only voted against the bill in the Senate, he had publicly denounced it on national television as a legal cancer spreading through the Constitution. What Judge Stones didn't realize, at least not yet, was that Kennedy wasn't in that courtroom because he had to be. He was there because he wanted to be. The silence that followed the judge's remark wasn't just awkward, it was strategic. Kennedy let it breathe, let the moment stretch. It was a pause not of confusion, but of precision, the way a chess master pauses before taking a queen. In the back row, a political correspondent whispered, "He's gonna wreck him." The reporter next to her didn't blink. "Not yet," she replied. "He's loading." The judge cleared his throat and gestured impatiently. "You may proceed, Senator, if you can keep your testimony within the bounds of legal relevance." Kennedy nodded once slowly. "Of course, Your Honor," he said. "I wouldn't dream of stepping outside the lines. After all, the Constitution already drew them for us." That line hit different. It wasn't loud, wasn't flashy, but it landed like a steady drumbeat, calm, righteous, and deeply unsettling for a man like Judge Stones. For the rest of his testimony, Kennedy spoke with the same measured tone, quoting court precedents, citing constitutional scholars, and laying out a meticulous argument against the state's position. He was every inch the Oxford-educated lawyer he once was, but with the delivery of a man who had learned the power of silence and timing in the halls of Congress and on the front porches of Louisiana. Judge Stones listened, but his earlier smirk had faded. The gallery leaned in, and while no one knew it yet, something had shifted. This wasn't going to be a simple hearing. It had just become something else entirely, a reckoning. Long before Senator John Kennedy stepped into that courtroom, long before the judge's smirk or the silence that followed, there was a young man from Zachary, Louisiana, who believed that words mattered. Not just for show, not for headlines, but because they carried the weight of principle. He wasn't always a politician. Long before the Senate floor or Sunday morning news shows, John Neely Kennedy was a kid with a borrowed library card and a stubborn belief that the Constitution wasn't just a suggestion. He studied hard, hard enough to land at Vanderbilt, then the University of Virginia Law School, then, improbably, Oxford. The boy from rural Louisiana went toe-to-toe with British scholars in dusty seminar rooms where the air still smelled like ink and empire. But while others chased titles or Wall Street careers, Kennedy came home. He always came home. He practiced law in Louisiana, not for prestige, but because that's where the fight was. The law to him wasn't just a career, it was a weapon, and his home state needed someone willing to wield it for the right reasons. He served as special counsel to the governor, where he read every word of every bill like it might be a bomb. Because sometimes it was. Years before anyone knew the name Andrew H. Stones beyond the local judiciary, Kennedy had already crossed paths with the man, indirectly but fatefully. Back then, Stones was a rising star on the state bench, known for his iron-fisted rulings and strict interpretation of public order statutes. In 2004, he upheld a state law that allowed Louisiana officials to monitor and penalize local publications for what they deemed as undermining institutional confidence. It was a euphemism so broad it could cover everything from investigative journalism to political satire. Kennedy hated that law. He fought it, not in the headlines, but in the backrooms where legislative language is born. As legal counsel to the governor, he quietly advised a repeal campaign. When reporters asked, he gave them nothing. But behind the scenes, he drafted revisions, proposed constraints, and built the case that the law not only violated the First Amendment, it reeked of authoritarianism. A year later, the law was overturned. Publicly, Stones accepted it as a political decision. Privately, he never forgot the name of the man who helped dismantle it. That man now sat in his courtroom. Which brings us to why Kennedy was there that day, not as a politician, not as a figurehead, but as a witness. The new law, the one being challenged in this case, was no coincidence. It was a modern remake of the old statute, rewritten, renamed, but reeking of the same rot. It used digital language now, terms like algorithmic integrity and online incitement, but its soul was the same. A legal muzzle wrapped in high-tech packaging. Kennedy recognized it the moment he read it. He issued a statement within hours of the bill's passage. This law is nothing more than a zombie statute, same poison, new bottle. The media ran with it. The term stuck. And when the lawsuit was filed, plaintiffs requested Kennedy's insight not just for legal context, but for historical pattern, because he had seen this before, he had fought it before. And now he would fight it again. His testimony wasn't political theater. It was personal. When asked by reporters why he chose to testify in person rather than submitting a written brief, Kennedy simply said, "Sometimes you've got to show up when the weather's bad." It wasn't just about legality. It was about legacy. And maybe, just maybe, it was about confronting something he had helped bury, but which had crawled back from the grave wearing new clothes and a new name. Inside that courtroom, Judge Stones may have worn the robe, but Kennedy carried the history. And history has a long memory. He didn't come to preach, he came to remind. He reminded the court that bad laws don't die when they're repealed. They wait. They linger in the margins of legal drafts, waiting for quieter times and bolder authors. And they return, dressed in urgency, cloaked in fear, disguised as safety. That was the real reason Kennedy sat in that witness chair with quiet authority, because he had read this script before. He knew its ending, and he refused to let it play out again on his watch. It's easy to forget that power repeats itself, that the same arguments once used to silence pamphleteers in 1775 were being recycled now to police Facebook posts, that the architecture of suppression evolves, but its blueprint remains stubbornly familiar. Kennedy knew, and he was here to say it out loud. When Judge Stones laughed, he thought he was mocking a relic. But what he didn't understand was that Kennedy wasn't clinging to the past. He was defending the future. The moment wasn't nostalgia, it was prophecy. And in the minutes that followed, that prophecy would begin to unfold, not in anger, not in noise, but in the precise, deliberate rhythm of a man who came not to argue with power, but to outlast it. The courtroom looked balanced on the surface. Polished wood, neutral colors, the flag of the United States standing tall behind the bench. But justice has never lived in furniture. It lives in action. And what unfolded in the next 45 minutes peeled back every layer of pretense, revealing something rotten beneath the ritual. Senator John Kennedy continued his testimony with the same careful tone he had maintained since entering the courtroom. He cited Brandenburg v. Ohio when explaining why vague incitement laws posed a constitutional risk. He referenced Reno v. ACLU to highlight the Supreme Court's position on government overreach in regulating the Internet. His words were measured, deliberate, not for effect, but for accuracy. Then it happened. Objection, the state's attorney interrupted. The senator is speculating on the intent of the legislature. Sustained, Judge Stones replied without hesitation. Senator, please confine yourself to observable facts. Kennedy nodded, adjusted his cuff, and continued. A minute later, he mentioned how prior courts had ruled that online platforms were, in effect, modern public squares, protected by the First Amendment. Objection, came another voice from the defense. That's an oversimplification of case law. Sustained, Stones said again, quicker this time. Let's not editorialize, Senator. Kennedy paused, his brow unmoved. Not a flinch, not a word. Just a blink and then a breath. Moments later, he mentioned the Packingham case. Third objection, third sustain. By now, the pattern was no longer subtle. It was scripted, rehearsed, predictable in its arrogance. The courtroom wasn't a venue for truth. It had become a stage, and Stones was determined to control the script. It wasn't that Kennedy was being disrespectful. He was, by all accounts, clinical, precise. He wasn't grandstanding. But it didn't matter. Stones seemed to hear politics in every paragraph and assumed theatrics behind every citation. He had made up his mind about Kennedy long before the senator ever opened his mouth. But the double standard became unmistakable when the state's legal team began their rebuttals. Each time Kennedy raised a legal precedent, they interrupted, and each time Stones sided with them. Then the roles reversed. The defense attorney, a sharp-suited man with all the charisma of a parking ticket, launched into a long monologue about national security, citing no case law and presenting no documentation. No one interrupted him. At one point, he implied that Kennedy's presence in the courtroom was itself a threat to the court's neutrality. A lawyer for the plaintiffs rose immediately. Your Honor, that characterization is not only inaccurate, it's inappropriate. Sit down, Judge Stones snapped. This is not a debate club. We will have order. Order apparently meant silence, especially from the wrong side of the aisle. Kennedy didn't object. He simply sat still, eyes steady, mouth set in that same unflinching calm he'd carried in from the hallway. But when the defense team, emboldened by Stones's leniency, began twisting his quotes into political accusations, something in Kennedy shifted. Not in his posture, not in his tone, but in his language. He waited for the attorney to finish yet another baseless critique, then turned slightly in the witness chair, gaze fixed on the judge. This court, he said slowly, almost like a man reading a plaque from memory, like memory, seems to be selective today. You could feel the air shift. There was no shouting, no sarcasm, just that line, suspended in the silence like smoke from a slow-burning fuse. Reporters looked up. A clerk dropped a paper and didn't bother picking it up. The courtroom wasn't erupting, but it wasn't breathing either. Stones didn't respond. He didn't need to. The tension in his jaw said enough. Kennedy wasn't grandstanding, he was signaling. The kind of signal you only send when you're certain you're being watched, not just by the people in the room, but by history itself. It wasn't just that he was being cut off. It was the frequency, the choreography, the unmistakable design of it. A federal courtroom where objections flowed one way, where the benefit of the doubt had a favorite, where the rules bent not under the weight of fact, but under the pressure of authority. Justice is blind, they say, but sometimes she peaks. And Kennedy, a man fluent in the language of power, was now marking every moment, not in rage, not in rebellion, but in record. Because injustice, when documented, becomes something else entirely. It becomes evidence. Outside the courtroom, news trickled slowly at first. A few legal correspondents noticed the odd rhythm of the session. A live blogger pointed out the imbalance in sustained objections. And on the sidewalk just beyond the courthouse steps, a law student watching the proceedings via live feed muttered to her friend, "He's building something. Watch." Inside, Kennedy sat still. 3 times he had been silenced. 3 times he had marked it. And when he spoke again, it wasn't to argue, it was to wait. Because the real testimony wasn't in his words, it was in the restraint, the signal, and the silence that followed. Judge Stones had just smirked again. It was the kind of smile that didn't belong in a courtroom, thin-lipped, leaning smug, full of the confidence of someone who believed their position made them immune to challenge. Senator Kennedy had just referenced a recent appellate decision protecting whistleblowers' speech online. Stones cut him off with a wave of the hand. "That may be how things work on cable news, Senator," he said, eyes narrowed, "but this court requires legal substance, not moral theater." There it was, the 4th interruption, not a reprimand this time, but a taunt. The insult hung in the air like smoke that refused to dissipate. The courtroom waited, instinctively bracing for Kennedy's response. But the senator didn't answer with words, not right away. Instead, he reached into a leather briefcase resting beside the witness chair, not rushed, not dramatic, just deliberate, like a man choosing a tool he knew he would need. From inside, he pulled a legal folder, thick, worn at the edges, marked with a single white label printed in bold. Judicial Overreach, J.A. Stones, 2005-2024. The defense attorney blinked. The judge stilled. The room leaned forward. "If I may, Your Honor," Kennedy said calmly, "since we are speaking of substance over theater, I'd like to enter a quote into the record. It comes from a ruling issued by this very court, dated July 14, 2011. Stones leaned forward just slightly, the smirk fading, replaced by something more cautious. "Proceed," he said, though it came out quieter than before. Kennedy opened the folder and slid out a photocopied ruling, its header clearly showing the case name, Louisiana Press Alliance v. State Department of Commerce. "The ruling," Kennedy said, "written and signed by Your Honor, reads as follows. Freedom of the press does not extend to false outrage. The role of journalism is to inform, not to incite." A ripple passed through the gallery. There it was, in black and white, a sentence that, if spoken from any political stage today, would draw headlines, outrage, and constitutional alarm bells. But this had come from a judge, a federal judge. And Kennedy had just placed it squarely in the center of the courtroom. "The problem, Your Honor," Kennedy continued, tone still even, "is that the First Amendment doesn't make room for your interpretation of emotional validity. It protects outrage, it protects dissent, and it certainly doesn't require approval from the judiciary before it extends its full rights to the people." The room fell into something deeper than silence, stillness. No one objected. No one moved. Even the court reporter had momentarily stopped typing, only to quickly catch herself and resume. Judge Stones cleared his throat, but whatever interruption he had planned never arrived. Kennedy turned a few pages in the folder, revealing a tabbed and color-coded index. "This folder contains 12 cases, spanning nearly 2 decades, where Your Honor issued rulings that not only pushed the boundaries of judicial discretion, but directly contradicted higher court decisions within the same circuit." A subtle gasp came from the plaintiff's table. Kennedy lifted the next document. "May I remind the court," he said, "that in Jenkins v. Bayou Citizens Coalition 2015, Your Honor dismissed a case involving political signage restrictions, calling the plaintiff's claims speculative performance art." He held up the document. The Fifth Circuit reversed that ruling unanimously. He placed that file on the table. Next, the case of Frazier v. Louisiana State University, 2018. A student journalist sued the university over denied access to public records. Your Honor ruled that student-run media was not a protected journalistic entity. Kennedy paused, then looked toward the bench. That ruling was not only reversed, it became a textbook case in First Amendment courses nationwide. The appellate opinion described Your Honor's reasoning as constitutionally incoherent. Another file landed, then another, and another. Kennedy did not raise his voice. He didn't need to. With each citation, the walls of Stone's authority chipped away, not with shouting, but with scholarship. One by one, he laid out the cases, always the same pattern. A ruling that favored control over speech, a dismissal of dissent, a quiet assumption that the judge's worldview was superior to constitutional precedent, and in nearly every instance, a reversal on appeal, not technicalities, not ambiguities, reversals with language that questioned not just judgment, but bias. Kennedy reached the final tab. "Finally," he said, "we have Delacroix v. Parish Council 2020. A woman arrested for live streaming a council meeting from her phone. Your Honor ruled that her broadcast was a disruption of order, but the appellate court ruled otherwise. They called the arrest a violation of basic rights, and your justification, quote, an affront to open government." He looked up directly at Judge Stone's now. "These aren't opinions, Your Honor, they're patterns." The judge looked pale, not visibly shaken, not yet, but different, like a man standing too close to a storm and realizing he'd forgotten his umbrella. Kennedy placed the last document on the table with deliberate care. "I bring these not as a political argument," he said, "but because this courtroom, this very bench, is presiding over a case that bears a haunting resemblance to the others. A law built to silence, a judge unwilling to question its motives, and a history, Your Honor's own history, that cannot be separated from what happens here today." It was a turning point, but no one stood to cheer. This wasn't theater. It was testimony, not the kind you give under oath, but the kind that speaks for those who never made it to court, the ones silenced before they could file a complaint, the ones who didn't have folders or microphones or a senator on their side. The judge didn't respond. The defense team stared ahead, blinking, unmoving. Kennedy, quiet now, simply leaned back in his seat. The folder sat on the table like a loaded question, and everyone in that courtroom knew they had just witnessed the balance shift, not with shouting, not with anger, but with memory, precision, and the calm fury of a man who had come to remind power that it answers to precedent, not preference. Senator Kennedy did not move quickly. He did not raise his voice, slam papers, or make the kind of dramatic gestures that feed cable news loops. What he did was slower, more precise, and far more dangerous. Because while drama can rile a room, documentation can collapse it. He reached into the folder again, this time pulling out a slimmer packet, stapled at the top, labeled in Kennedy's handwriting. He held it in the air, not as a threat, but as a courtesy, a warning shot wrapped in legalese. "I'd like to focus the court's attention," he said, "on 5 particular cases. 5 rulings authored by this court, which when viewed together form not just a pattern, but a philosophy of judicial discretion that consistently lands on the side of silence over speech, power over principle." There was no objection, not yet. The defense attorney shifted in his seat, whispering something to a junior aide. Judge Stone's remained motionless, one hand resting on the bench, the other gripping his gavel like a rail on a fast-moving train. Kennedy began. "The Baton Sentinel case, 2011, he said. A small investigative outlet publishes a series of articles implicating state officials in contract rigging. The state responds by citing them for violations of an obscure business disclosure law, claiming they failed to register as a formal media entity under new regulations. The Sentinel sues, claiming First Amendment retaliation. Your Honor dismissed the case, writing that journalistic freedom does not exempt an entity from regulatory compliance. The Fifth Circuit reversed that decision, stating that the law was weaponized to punish dissent, and your ruling, and I quote, betrayed a fundamental misunderstanding of press protections under the Constitution. He placed the document face up on the table. Barnett v. State Education Board, 2016. A public high school teacher raised concerns about the politicization of curriculum content in staff meetings. He was reassigned, then fired. He sued, citing retaliation for protected speech. Your Honor ruled that his comments were internal disruptions and not protected. The appellate court reversed the decision, unanimously. They wrote that your opinion collapsed all distinction between institutional discipline and ideological suppression. The courtroom was still as a cathedral. Armstrong v. City of Monroe, 2019. A private citizen live streams a police stop. The footage shows a clear overuse of force. The city charges him with obstruction and enacts an emergency rule banning public video capture of active law enforcement operations. Armstrong sues. Your Honor dismissed, stating privacy concerns for law enforcement outweigh unsanctioned digital surveillance. The Fifth Circuit responded with one of its most scathing rebukes to date. The ruling substitutes subjective discomfort for objective constitutional principle. Another file placed gently beside the last. Kennedy looked up only briefly, long enough to ensure the court was still listening, not just hearing, but absorbing. They were Fuller v. State Health Authority, 2022. A traveling preacher delivers outdoor sermons protesting vaccine mandates. No threats, no violence, just megaphones and Bibles. The state charges him with unauthorized assembly. Fuller sues. Your Honor ruled that his speech was not constructive discourse and therefore not shielded. The appellate reversal was immediate and historic, they wrote. This court cannot become the arbiter of tone in free speech. And most notably, the lower court's reasoning endangers the very principle of pluralism in public health debates. The document landed with a faint slap. Stones didn't blink. Finally, South Bay Digital v. Louisiana Public Policy Bureau, 2023. A decentralized group of citizens organizes through a private social media group to challenge new zoning laws. The state alleges the group is spreading coordinated misinformation and orders the platform to disable it. The group sues. Your Honor dismisses the suit on the grounds that online collectives lacking formal leadership lack standing. The Fifth Circuit doesn't just reverse. It writes a majority opinion warning against the judicial trend of dismissing digital rights based on outdated models of organization. They describe your ruling as, and I quote again, a failure to adapt judicial logic to the evolving architecture of modern free association. Kennedy stacked that file atop the others. He wasn't smiling, he wasn't gloating. He was building, brick by brick, a record, a pattern, a quiet indictment dressed in appellate decisions and legal language so sharp it left no need for theatrics. Your Honor, he said finally, what ties these cases together is not ideology. It's not partisanship. It's not even error. What ties them together is a method, a judicial tendency to define disruption as danger, to see dissent as defiance, and to rule accordingly. And while courts are permitted interpretation, they are not permitted erosion. The Constitution does not allow preference to masquerade as principle. The courtroom did not move. Even the air felt still, as though holding its breath. Judge Stones said nothing. The defense team, once animated, was frozen. Kennedy looked down at the stack of documents, hands resting lightly on either side. These are not grievances, he continued. They are precedents. Not my interpretation of the law, not my opinion, but the written judgments of appellate courts, constitutional experts, and in several cases, your own colleagues in the federal judiciary. He paused, then added something quieter. You have every right to disagree with protesters, journalists, preachers, and teachers. But when that disagreement manifests as a pattern of legal rulings that consistently suppress their rights, that is no longer jurisprudence. That is bias, institutionalized, documented, repeated. A few rows back, a young reporter whispered into his phone without looking down. Others typed furiously, chasing to keep pace. Kennedy's tone changed slightly, not louder, just more deliberate. And now this court is presiding over yet another case, one where citizens claim their voices have been silenced by the state, and where your honor's record, respectfully, cannot be considered neutral. You are not a bystander to this legal moment. You are a returning participant. The echo of these rulings is not distant. It is present. It is shaping the very way this hearing unfolds. He let that rest in the air. No closing argument. No dramatic finish. Just weight, settling like a stone dropped in still water. Stones gripped the gavel again, but did not lift it. For the first time, it was unclear who controlled the room. Kennedy had not demanded recusal, not yet. He hadn't needed to, because what had just happened wasn't a political takedown or a courtroom ambush. It was something colder, more surgical. It was a reckoning made of paper, stacked page by page. And in that moment, the weight of 20 years of rulings no longer sat with the plaintiffs. It sat behind the bench, in silence, in record, inescapable. By the time Senator Kennedy stepped off the witness stand, the room had stopped pretending to be neutral. It wasn't open defiance, not yet, but the posture of the gallery had changed. Eyes no longer looked to the bench for authority. They looked to the man who had, with nothing more than folders and facts, turned the tide of a federal courtroom without raising his voice once. He gathered his papers quietly, nodding to the attorneys seated nearby. No triumphant glance, no verbal parting shot, just that steady walk down the aisle, back straight, every step echoing louder than the judge's gavel ever had. The doors closed behind him with a gentle click, but inside, the silence remained loud. Outside, it exploded. Reporters who had been tapping quietly in courtroom corners now sprinted toward news vans. Microphones were whipped out mid-run. Cameramen who had been told to wait outside now shoved through clusters of law students, interns, and clerks who had watched the session via live feed in the hallways. Everyone had seen it. And no one was waiting for a press release. The moment Kennedy cleared the steps of the courthouse, phones were already out. By the time he reached the sidewalk, a hashtag was born. /stoned by Kennedy. It hit the trending charts in under 20 minutes. By the end of the hour, it was #1 nationwide. Clips started flooding social media, grainy at first, recorded from courtroom monitors, over-the-shoulder smartphone videos of video feeds, snippets of Kennedy laying down case after case like a man disassembling a weapon blindfolded. Users stitched in reaction videos, added dramatic music, slow-motion overlays, and legal commentary. TikTok ran wild. Twitter turned legal. YouTube reformatted everything into 10-minute explainers. Even Instagram Reels started quoting appellate opinions. The quote that traveled fastest was not the fiercest, not the most dramatic. It was this court-like memory seems to be selective today, simple, haunting. A line that became a national mirror. Somewhere in northern Louisiana, a man named Jacob Armstrong sat in his garage, watching a live stream on his phone. His name had surfaced in Kennedy's folder, mentioned in the third example of judicial suppression. Armstrong had almost forgotten that chapter of his life, the court case, the legal fees, the cold dismissal. He watched Kennedy speak with clarity about that moment, the ruling that nearly bankrupted him for filming a police encounter in his own neighborhood. He posted one line, "We thought they forgot." Kennedy didn't. It got over 1 million views in a day. In Baton Rouge, the editor of the Baton Sentinel published an open letter titled, "12 Years Later, Someone Read the Transcript." It closed with a sentence that struck a chord across the country. When the law failed us, history caught up. Then came the media wave. CNN aired an emergency legal roundtable. The host began with a single sentence. Today, a senator cross-examined a sitting judge with the Constitution as his co-counsel. Fox News, initially cautious, aired extended commentary with split-screen analysis, comparing Stone's rulings to their appellate reversals. Even the Cato Institute, no friend of performative courtroom antics, released a statement titled Judicial Power Without Accountability: Why This Moment Matters. By evening, a spokesperson for the Judicial Ethics Oversight Board confirmed they were officially reopening their review of Judge Stone's past rulings, not based on new accusations, based on new context. And that was the point. Kennedy hadn't accused Stones of corruption. He hadn't claimed bribery or collusion or partisan manipulation. What he had presented was something more dangerous to unchecked power: pattern. Consistent decisions, carefully cited, fully documented, and cross-referenced with higher court reversals that questioned not judgment, but intention. The legal system, designed to resist spectacle, now faced something it could not dismiss. Because this time, the case had not been made through rage or media campaigns or public protest. It had been made in the courtroom, on record, and the record didn't lie. Over the next 24 hours, law schools across the country began circulating transcripts of the session. Professors emailed out clips. Students formed late-night study groups not to prep for finals, but to understand what they had just seen. One constitutional law professor at Georgetown called it the most surgically delivered rebuke of judicial inconsistency she had ever witnessed. In Dallas, a civil liberties firm reopened two of its own archived cases, suspecting now that they too might share DNA with the rulings Kennedy had exposed. Legal aid clinics from Oakland to Tallahassee reported a spike in inquiries from former plaintiffs wondering if their cases had been dismissed by a certain pattern, rather than fair application of the law. For the first time in over a decade, the name Judge Andrew H. Stones did not inspire the usual reverence in legal circles. It inspired scrutiny. By midnight, the Fifth Circuit's press office issued an unusually terse statement. All judicial conduct allegations will be reviewed with impartiality and seriousness, regardless of tenure or rank. And somewhere, alone in his chambers, Judge Stones sat behind his bench, not presiding, but watching. The courtroom was empty, the silence no longer his to command, the gavel beside him no longer a symbol of control, but of memory. He had faced no outburst, no scandal, no shouts, only documents, only questions. And a senator from Louisiana who, with nothing but records and time, had reminded the country that sometimes justice does not come with thunder. Sometimes it arrives with a folder, and everyone takes note. 1 week later, the announcement came quietly. No press conference, no cameras, just a statement from the federal judiciary's Public Affairs Office, posted at 9:42 a.m. Eastern Time. Due to ongoing health concerns, Judge Andrew H. Stones will be taking an indefinite medical leave from the bench. All pending cases under his docket will be reassigned. There was no elaboration, no farewell, no apology. And yet everyone understood exactly what it meant. The silence that had protected him for years had finally broken, not by scandal, but by scrutiny, not through politics, but through precedent. A folder, a timeline, a series of rulings laid bare. And once the record spoke, the robe could no longer shield the man wearing it. Inside the legal community, the response was swift and profound. Law schools updated their syllabi. Professors replaced a scheduled lecture on judicial ethics with a new case study. They called it the Stones reversal, and it was no longer about a single judge. It was about how power survives when no one asks questions and what happens when someone finally does. Clips from the hearing became teaching tools. Kennedy's quiet line, "This court, like memory, seems to be selective today," was printed across classroom whiteboards, not as a slogan, as a warning. At Tulane, a professor of constitutional law ended her semester by playing the final 15 minutes of Kennedy's testimony. The class, usually restless by the last week of lectures, sat in complete silence. Not because it was dramatic, because it was honest. In an interview request flood that spanned every major network, Kennedy declined them all. He issued no victory statement, held no press event. His office released a single quote. "The law remembers, even when people don't." It was enough. That single sentence was retweeted over 1 million times, printed on posters, written into legal blogs, and quoted at graduation speeches from Harvard to community colleges in rural Texas. But the moment that mattered most didn't come from a courtroom or a camera. It came in a handwritten letter. It arrived in Kennedy's office 3 days after Stone stepped down, written in blue ink on ruled notebook paper. The return address was from a small town in Mississippi, barely known to most. "Dear Senator Kennedy," it began, "I watched the hearing with my high school civics teacher. I didn't know who you were before that day. I didn't think the law was something people like me could do anything with. It always seemed like it belonged to people who already had power. But watching you stand up there and do what you did, with just papers and history and a steady voice, I changed my mind. Today I decided I want to go to law school." The letter was unsigned, just one closing line, because someone should keep remembering the story did not end with headlines. It did not end with a resignation. It ended with a ripple. A quiet shift in how people saw the courtroom, the bench, and the people who stand before it. Because when one person uses truth to challenge power, not with anger, but with preparation, something lasting is created, not a spectacle, a standard. And in that courtroom, on that day, John Kennedy reminded the country of something it had nearly forgotten, that the law does not belong to judges. It belongs to the people willing to defend it.